I don't want to repeat what my colleagues have said, so I'll try not to. But we have heard about the need for more oversight of the department rules and to place that in the hands of the legislature. Before we really think about that, we have to understand what's in the law right now. What have we already required? So the Administrative Procedures Act governs the rulemaking process. How does that work? First, a request for the rulemaking has to come and proposed draft rules must be submitted to the Office of Performance and Transformation, which many of us know used to be the Office of Regulatory Reinvention. Included in this is the state or federal statutory or regulatory basis for the rule, the problem the rule intends to address, an assessment of the significance of the problem, and, if applicable, the decision record. That office can only approve a request after it's indicated that there are appropriate and necessary policy and legal bases for approving this request for rulemaking. After that, an agency has to do a regulatory impact statement. Now, I was going to read the conditions that are in that statement, but there are 28 separate conditions, many dealing with small business, many dealing with local government, many dealing with the necessity, many dealing with the appropriateness of the geographic location. I mean, I'm going through this list and it's crazy, all the things that these departments have to provide. I can't believe we ever actually get rules that are adopted having to go through these 28 different rules. But the bill before us adds to that. It adds a requirement that the director of the agency provide a statement of the specific fact that established the clear and convincing need to adopt a more stringent rule and the unique characteristics in Michigan that necessitate these more stringent factors than the feds. Additionally, if an agency proposes a rule stricter than federal rule, that will apply to and have a disproportionate impact on small business. A small business impact statement must be submitted. So now we're doing a second statement. On top of the 28 rules, you need a small business impact statement. And then that goes through a whole variety of things that I'm not going to list. And all of that is before the JCAR process even starts. I think we have, in past legislative days and past legislative sessions, I think our previous colleagues have addressed many of the concerns that have been raised, and I think that this bill really is unnecessary. So I hope that we will reject this bill in the same way that the governor rejected this bill a few years ago, and actually try and work through the appropriate process and maybe scale this back and update the Administrative Procedures Act instead of just punting our authority to the federal government. Thank you.
Madam Speaker, on the question of final passage of House Bill 5613, there are 61 aye votes and 47 nay votes.
A majority of the members elected and serving having voted, therefore the bill is passed.